Good afternoon and welcome everyone to today's session. My name is Baljinder Gill. I am the Community Training and Outreach Coordinator with Legal Aid BC. On behalf of Law Foundation of BC and Legal Aid BC, we welcome you all in today's session. Before we start the session, I would like to begin by acknowledging that the land on which we gather today is the traditional unceded territory of the Coast Salish peoples, including the territories of the Musqueam, Squamish, Tsleil-Waututh First Nations. It's my privilege to welcome today Danielle Sabelli. Danielle is a lawyer in the community law program at CLAS and worked primarily in the areas of residential tenancies and income assistance. Danielle has provided representation to clients at various administrative tribunals and the BC Supreme Court prior to joining CLAS. Please join me to welcome Danielle. Thank you very much, Danielle, for doing today's session. And also all the questions and answers, please post them in Q&A box, and we will pick up the questions from there and ask Danielle at a convenient time. Thank you, Danielle.
Thank you, Baljinder. And thank you to all of you for joining me today. We're going to talk about procedural fairness in administrative hearings. But before I begin, I just wanted to invite all of you to let me know what other administrative tribunals you all have appeared in front of. I'm going to take a guess and say that I imagine most of you have probably appeared before and are appearing regularly before the residential tenancy branch. And so this presentation is pretty much geared towards providing you sort of an overall comprehensive understanding of procedural fairness. But where the opportunity arose, I slid in some cases, particularly cases that are applicable to the RTB context. But I just wanted to take some time to see what other tribunals folks are appearing before outside of the residential tenancy branch. So if you have any other tribunals you want to highlight, please feel to include them in the chat right now. I'll just have a look so that I have a sort of a better sense of what everyone is doing and where folks are. Okay, so we have EAT, Employment Standards Tribunal, Social Security Tribunal, and we have someone who is doing a CRT hearing. So mainly income security, some employment standards, and a CRT hearing as well. Excellent. Okay. Well, thanks to everyone who included the various tribunals that they've appeared before outside of the residential tenancy branch. One thing you'll definitely hear throughout my presentation is that context is very important. So what might be applicable to one tribunal may not be applicable to other tribunals. So just something to keep in mind. And of course, always useful to look up case law for that particular tribunal to see whether or not there have been decisions made about a particular aspect of procedural fairness. But as mentioned, mostly the case law I'm going to be highlighting is going to be in the residential tenancy context, but I think it could be applicable as well to most of these tribunals that you all have highlighted as well. So thank you everyone who took the time to plug in some additional tribunals that you appear before. Okay. So to start, I thought it would be a good idea to kind of go over what administrative tribunals are. And so if we look at the traditional model of governance, Parliament and the legislature pass laws, and the executive is meant to implement and enforce these laws. And the courts, for their part, interpret and apply the laws that Parliament and the legislature pass in the course of adjudicating a particular dispute. The criminal code gives us a good example of that traditional approach. Parliament makes laws setting out crimes. If people violate those laws, they are prosecuted by the Crown and then tried by the court. So that's this traditional model of governance. And so the typical administrative scheme basically sets out the legislature's basic objects and provisions in a general statute, but But unlike the traditional model, most of the heavy lifting was not done by regulations adopted by the executive branch or government under orders in council. So to administer these government-made rules, these various bodies were created. And there was always these tribunals, which are a body of people who are appointed by the government on a permanent or semi-permanent or ad hoc basis to decide issues arising under the scheme between citizens and the state, and sometimes between citizens and citizens. That's primarily what's going on at the CRT, I imagine. And so this resulted in a dramatic shift into the question of who is doing society's judging. Vast and unlimited stretches of law and conduct that formerly fell under the jurisdiction of common law were now being swallowed up by these new schemes and being adjudicated by tribunals. The legislature could not remove the constitutional power of the court, but they did prove that they could shift most of the work to tribunals, to administrative tribunals. And so more and more administrative tribunals regulated the issues that were often created by modern society. And it was now about who was enforcing these new laws and interpreting the ambit of these provisions. And so, as we all know, administrative tribunals make decisions on behalf of federal and provincial governments when it is impractical or inappropriate for the government to do so itself. Tribunals engage in fact-finding and have the power to impact personal rights. And this is why tribunals are seen as quasi-judicial. And the impact of administrative agencies on the lives of individual Canadians is great and likely actually surpasses the direct impact of the judiciary. Most people are probably encountering administrative tribunals more so than they're encountering the actual court. So the administrative tribunals obviously do a lot of heavy lifting in terms of adjudicating a lot of the day-to-day experiences that people encounter. Now, of course, we all know, as advocates working within administrative tribunal, we know that the rise of the administrative tribunals and administrative tribunals adjudicating most of the issues that people are encountering does pose a bit of a problem. How could we have all the benefits of a tribunal justice while still maintaining the rule of law? How could the public be sure that government-appointed tribunal members would hold fair hearings and stay within the ambit of their administrative powers? And additionally, would the gains made in the long fight for rights and fair adjudication before the courts be lost when appointed board members, accountable to no one but the government they hoped would reappoint them, decide the rights and wrongs of people's disputes with each other and within the state? So we see that a lot of these questions, and I'm sure a lot of us struggle with these questions because, as we know, administrative tribunals do not have the same level of procedural protection as the court would. And so because of that, in the first half of the 20th century, the court sort of developed two modes of control to ensure the rule of law was being preserved at administrative tribunals. And so they enunciated principles of natural justice that assured procedural fairness. And at common law, the principles of natural justice are encapsulated in two central ideas. The first idea is that the decision maker should neither judge their own cause or have an interest in the outcome of the case before this. And this is summarized in the Latin maxim, and I may be mispronouncing this, but nemo judex in sua causa debet esse. Pardon me for the attempt at trying to say that correctly. That's essentially rules about procedural fairness that touch upon ideas of independence of the tribunals, reasonable apprehension of bias. Basically, administrative tribunals and all kinds of decision makers aren't supposed to adjudicate with any sort of bias. So that's the first one. And the second idea requires the decision makers hear and listen to both sides of the case before making a decision. This is probably what most of us are familiar with and often struggle with at tribunals. And this requirement has been summarized in the Latin maxim, audi alterum partem. And I mention the Latin maxims because sometimes it's helpful to actually search those when doing case law research, because sometimes judges will like to go back to the Latin maxims. So they're still used. So I thought it was important to mention them here. And also, again, because it might be helpful when doing some research as well to use those as search terms. And so both the nemo judex and the audi alteram partem maxims inform the right to an independent and impartial proceeding. Now, most of you probably know that Chief Justice McLaughlin had delivered a very well-known paper called The Roles of Administrative Tribunals and Courts in Maintaining the Rule of Law. And in this paper, she recognized the integral role of administrative tribunals in the maintenance of legal order and spoke of the ethos of justification, meaning that the exercise of public power must be justified to citizens in terms of rationality and fairness. And so I didn't reproduce the quote for you in the slides, but basically Chief McLaughlin, a notable quote from this report is, she says, fair procedures, equitable treatment, and responsiveness to the public are cornerstones of a system of administrative tribunals built according to the rule of law. I suggest that in many important ways, it falls to the members and support staff of those administrative boards to ensure that every person dealing with the state is treated fairly and with respect. Now, we often will shorthand procedural fairness, call it fairness, just call it procedural fairness. But it's important to also not lose sight of the fact that the procedural character is procedural fairness is a duty. It's a duty of procedural fairness. And it's concerned with ensuring public authorities act fairly in the course of making decisions and not with the actual outcome of the decision. So it's important to, again, remind oneself that this is a duty and certain tribunals may or may not have that duty. We'll get into that a little bit more later on, but it is actually a duty that is imposed onto the administrative tribunals and decision makers as a whole, for that matter. And so historically, the stance of the court towards administrative tribunals has been sort of negative. The court did a bit more limiting, reining in, supervising, overseeing, and constraining administrative tribunals. However, most of you probably know that that's no longer the case. Now we see, in the current state of judicial reviews of tribunal decisions, we see the court has completely shifted, and the courts tend to be deferential to administrative tribunals where it seems like that's what Parliament intended. So when an enabling statute has what's called a privative clause, at that point, the court's likely going to be very deferential to the tribunal because the court sees the tribunal as an expert in their home statute, their policies, procedures. They're adjudicating these matters day in, day out. So the court's not. So the court's going to often defer to tribunals that have a privative clause. Now, as mentioned, I am going to note some examples with respect to the Residential Tenancy Act. And the Residential Tenancy Act does have such a privative clause. It's section 84.1, subsection 1. And so courts will defer to tribunals when tribunal decisions are being brought to the court for judicial review. Many of us who've probably appeared before the RTB might struggle with that, might struggle with the fact that the RTB decision makers are often seen as experts, when I'm sure we've all had our share of experiences where that didn't seem to really be the case, or it didn't really seem that the arbitrator knew enough about the enabling statute, laws, policies, regulation that would warrant deference, that their expertise maybe wasn't robust or comprehensive enough, to the extent that the court should start from the point that, the RTB was probably correct in making this decision, prove me wrong. So that's those. It's hard for me often, when I get a decision of the RTB that's maybe lacking in reasons or a very obvious, patently unreasonable error. It's really challenging because, again, if you bring this then to the court, then you're kind of already starting at a level where deference is going to be given to the RTB, and you have to kind of come out of that hole. So it poses a challenge. And it is, yeah, as I mentioned, it is hard sometimes to hear that. And in addition to that, we also know that tribunals at times are inefficient, backlogged, underfunded. These reasons really contribute to maybe the types of reasons that, again, we don't feel are necessarily comprehensive, or situations where we don't think our clients received a fair hearing. That's largely due to a resource issue, and just underfunding and backlog, and expediency tends to get prioritized over quality decision making. Now, even though most administrative tribunals most of them, are executing a public duty and are expected to do so in a procedurally fair manner, they don't always have to. And you're going to see, again, as we go through the presentation today, the situations where that's not the case. Because again, it's not sort of an absolute right that people have. Again, context is very specific. The courts will often think about the makeup of that tribunal, what that tribunal is supposed to accomplish, what the legislature intended for that tribunal to accomplish, and will make decisions about procedural fairness based on those other kinds of factors and criteria, which we're going to get into a bit further. So the threshold question. So as I mentioned, not all tribunals are required to apply procedural fairness in their adjudication processes. And so the first sort of step towards determining whether or not that tribunal must afford parties procedural fairness, they have to sort of first consider this threshold question. And so at this stage, this would be the court doing this sort of review, because it's ultimately we're talking about a situation where someone may have been denied procedural fairness at the tribunal, and it's now advanced to the court for judicial review on the grounds of a breach of procedural fairness. So at this stage, what the court is thinking about is whether or not this is the kind of decision that would attract some procedural rights. So at this stage, the court's not asking what those rights are going to encompass just yet, but only the preliminary question of whether there should be entitlement to procedural fairness at all. So in other words, the court is asking whether it should review a decision maker's procedures, or whether it's more appropriate to conclude that whatever the decision maker decides to do is sufficient. Generally, if a result of a decision is made that affects the individual's rights or interests, there will be some minimal entitlement to procedural fairness. So all of the tribunals that those of you who included the various tribunals in the chat, like the SST, the Employment Standards Branch, and the Civil Resolution Tribunal, Residential Tenancy Branch, those are all the kinds of decisions that would affect an individual's rights or interests. So they're all likely going to attract some procedural fairness, that the decision makers in those situations ought to apply some degree of procedural fairness. So traditionally, the determination of whether this threshold has been passed was carried out at common law. So a fair process may be required, even if not specifically provided in the statute. We do have some guidance on that. We have some rules of procedure that would suggest, and we'll talk about this a little bit further, that kind of entrench the degree of procedural fairness, or the acknowledgement that procedural fairness should be afforded for that particular proceeding. But that doesn't have to be there in order for a tribunal to have that requirement that they abide by some procedural fairness. And in the context of the RTB, we do have several decisions that do confirm the RTB contemplates a high degree of procedural fairness. So in the case Chena and Nguyen, the court acknowledged that the Residential Tenancy Branch rules of procedure contemplate a high level of procedural fairness. The court says the RTB rules govern dispute resolution proceedings. They contemplate a high level of procedural fairness. Any person dealing with the RTB would have a reasonable expectation that the RTB rules would be complied with. I I cannot stress enough how important it is to always go back to the basics, go back to the rules, go back to the policy, go back to the act, and read it very closely and very carefully. Because I know myself, having, I've done this myself where, I just sort of took advantage that I thought I knew a rule or I thought I knew a policy, but then when I was sort of forced to go back to look at it, there's something in there that I didn't catch before. So I would definitely recommend revisiting, especially in the residential tenancy branch context or any context that has rules or procedures that are published to read them very closely, because a close reading of that will also reveal to you the level of procedural fairness that tribunal is expected to provide to parties. And again, we have case law that confirms that, the rules of the RTB definitely exemplify that, definitely suggest that not only are parties entitled to procedural fairness, but a high level of it. So it's always good to just glean over the rules when you're thinking and contemplating procedural fairness for a particular tribunal. There is another case called Kekals and British Columbia. I don't think I've reproduced it for you in the slides, but the citation is 2012 BCSC 897. And in this case, the court observed that with respect to proceedings before the RTB, it should be understood that in a system as stripped of, a direct quote, it's paragraph 37. It should be understood that in a system as stripped of the usual guarantees of due process as this, with no record, with no hearings by telephone, and lay participants appearing without assistance or advice, extra care must be taken to ensure fairness and the appearance of fairness. And so, of course, this applies to other types of tribunal settings where, again, those usual guarantees of due process aren't available. We don't really have much to work with when we're dealing with the RTB, and that's the same for a lot of other tribunals. So that extra care has to be taken, that the decision maker has that extra responsibility to ensure that processes are fair. So now we're going to get into the content of procedural fairness and sort of what a judge will have to think about when considering whether a particular tribunal is required to apply procedural fairness and the level at which they're supposed to apply it. So if the court determines the threshold for some form of procedural fairness has been met, it must then address the degree of procedural fairness and what those procedures will be. So in terms of the degree, many of you probably are familiar with the Baker case. The factors for determining the degree of procedural fairness come from the Baker case. Now, most of you probably might know about the Vavilov case. It was a recent Supreme Court of Canada case that really tried to synthesize the mess that's been administrative law in Canada. And Vavilov did touch upon procedural fairness, and it does seem that the Baker factors are still relevant and applicable to the degree of procedural fairness that a tribunal should afford parties. So we still use Baker, and the facts of Baker, thought they're important to note. So Baker, for those of you who don't know, it is a Supreme Court of Canada decision. It was a case about a woman, Miss Baker, who was facing deportation for overstaying. Ms. Baker requested the minister use their discretionary powers to allow her to remain in Canada with her 4 Canadian-born children on humanitarian and compassionate grounds while she applied for permanent residency. Ms. Baker argued that her mental state would worsen if she were forced to return to Jamaica and that her children were dependent upon her for their care. Her application, unfortunately, was denied. The immigration officer who was assigned on this case wrote up some really inflammatory notes about the merits of her application. They're just handwritten notes. They weren't really formalized or anything like that. And although the court decided she was entitled to procedural fairness protection, the content of the duty was pretty minimal. Despite the relative informal nature of the notes of the information officer, the court found that they were sufficient to act as reasons. So given the nature of the the IRB, the court found that it was completely fine that some informal handwritten notes could constitute reasons for the decision. And the court also determined that an oral hearing was not required. And the court determined that it was enough that she was permitted to provide written documentation and written submissions. So you can see in a case that had really, really harsh consequences for the person involved, there was not a whole lot of procedural fairness granted to Ms. Baker. And so even though we get the five Baker factors from this case, when we actually read the case and read the facts of the case, it's pretty hard and it's pretty unbelievable, again, given what was at stake for Ms. Baker and the little procedural fairness she was actually afforded. So again, that, I think, reminding oneself of what happened in Baker is good, because again, then we sort of see how the courts kind of lean towards whether or not procedural fairness and the degree of procedural fairness that should be given. I'm sure we can all agree that it's probably not ever enough, that the courts often require a level of procedural fairness that we as advocates probably would disagree with and would think is not enough, unfortunately. So as mentioned, we added the Baker case. We do get the five Baker factors. Now, the court also emphasized in Baker that procedural fairness is flexible and entirely dependent on the context. And in order to determine the degree of procedural fairness owed in a given case, the five factors are as follows. The court will consider the nature of the decision. The court will consider the nature of the statutory scheme, the importance of the decision to the affected person, the presence of any legitimate expectations, and the agency or administrator's choice of procedure. And I'm going to go through each of those a little bit more in depth. But I do want to say this list is not exhaustive. None of these Baker factors are, in theory, more important than any other. And it's not unusual for the courts to conclude that some criteria supports a high degree of procedural protection in a particular circumstance, while others suggest a lower degree of protection. So having determined the general level of procedural fairness, the court will then decide from a range of possibilities what specific procedures are required. And we are going to go into what those are. But first, I want to expand a little bit upon the five Baker factors. So in regards to the nature of the decision being made and the process followed in making it, decisions that are considered quasi-judicial in nature are likely to demand more extensive procedural protection than purely administrative decisions. So again, I think for most of us, the kind of work we're doing and the kind of tribunals we're appearing before are going to, again, attract a degree of procedural fairness. I don't know that any of us are doing any kind of purely regulatory licensing type of work where there's not much of an impact on a person's personal interests or privileges. So I think for the most part, we're all probably engaging in tribunals that should attract a higher degree of procedural fairness. In Baker, Justice LaRue Dubé said that the more the process provided for, the function of the tribunal, the nature of the decision-making body, and the determination that must be made to reach a decision resemble judicial decision-making, the more likely it is that procedural protection closer to the trial mode will be required by the duty of fairness. And again, most of us are involved in tribunals that require us to present evidence, to apply the facts to the law, and most of the tribunals we're appearing before are definitely closely resembling the court's processes. Okay, the nature of the statutory scheme and the terms of the statutes pursuant to which the body operates. As mentioned, very important to pay close attention to the legislation that authorizes a particular decision to be made. Also, the case law will help to frame what the statutory intent is for a lot of the acts that we certainly encounter. The Residential Tenancy Act, there's no shortage of law that explains what the intent of the RTA is and that it is benefit conferring legislation. And greater fairness protection will usually be required if a final decision must be made, but a decision need not be final in order to attract a high degree of fairness protection. So interim decisions, interim orders, those kinds of things could still attract the duty of fairness. It doesn't always just have to be the final decision itself. In BC, we do have the Administrative Tribunals Act, which again, I'm sure most of you are familiar with, and this empowers tribunals to enact their own rules. And so critical to remember that where a statute specifies or denies a certain procedural right, the statute's going to prevail over the common law. So where there is no specificity in the statute, the common law may be read in to supplement the provisions of the statute. Off the top of my head, I can't think of any provisions that would kind of just clearly deny a certain process or procedure related to procedural fairness. But if you were to encounter that, then the statute is going to prevail over the common law. And enhanced procedural protection may also be required if there's a second level of proceedings in order to allow for meaningful participation in those proceedings. So for example, the existence of a right to appeal within the tribunal itself, like an internal appeal mechanism, is an important consideration in deciding whether and to what extent reasons for a first level decision are required. And as you'll see later on in the presentation, the right to reasons is part of this framework. Now it's kind of, but because in BC and because of the Administrative Tribunals Act, the way the right to reasons is dealt with is not so much in the context of procedural fairness, even though historically that is usually under the umbrella of procedural fairness. I'll explain why that is later, but that's what that final point is relevant to. So when you do have an internal appeal mechanism, there might be that enhanced procedural fairness that's required and more of an obligation for the tribunal to provide reasons that are adequate and understandable. Okay, the importance of the decision to the individual affected. So the content of the duty of fairness increases in proportion to the importance of the particular decision to the person it affects. And in Baker, Justice LaRue Dubé cites Justice Dickson's observation in a case called Kane and Board of Governors. And Justice Dickson says a high standard of justice is required when the right to continue in one's profession or employment is at stake. And so I think, one can certainly argue that if a high level of fairness is required when someone's employment is at stake, I think we can make similar arguments when someone's housing's at stake, when someone's income is at stake. Again, a lot of the work that most of us do, what is at stake is something extremely significant on our clients. So I think for the most part, we can make these kinds of arguments because the consequences of a particular outcome are going to have harmful consequences on our clients for the most part. So I think if the courts kind of identified the loss of employment being a high stake type of situation that will attract a high standard of procedural fairness, I think we can make the argument for a lot of other situations our clients are in. Okay, the legitimate expectation of the person challenging the relevant legislation. So the doctrine of legitimate expectation may extend the content of the duty of fairness on the basis of the conduct of the tribunal in particular circumstances. So for example, a person might be led to understand that they will be afforded a particular procedural protection, such as an oral hearing, before a decision is made, even though that level of protection might not otherwise be required. So if if you're dealing with a tribunal that doesn't normally do oral hearings, but the parties were led to believe that an oral hearing was going to happen through some form of communication, then they have that legitimate expectation that they're entitled to that oral hearing. And in these circumstances, if that person does have a legitimate expectation that an oral hearing will be held, then the public authority will have to hold that oral hearing. So legitimate expectations of procedural fairness may arise out of conduct such as representations, promises, undertakings, or even past practices or current policy of a decision maker. You can certainly raise the issue of legitimate expectation if you know, having worked within a particular tribunal system, that this is how things have always been done. You might have a legitimate expectation to continue to rely on that. And so more controversially, a legitimate expectation may also arise if a person is led to expect a particular outcome from the decision-making process. Now, a public authority might have policies that suggest such an outcome, or perhaps an official may give an undertaking that a particular decision will be made. For example, an undertaking that a license will be granted may give rise to a legitimate expectation that a person is going to receive a license. However, public authorities must also be entitled to change their minds. As a result, the doctrine of legitimate expectation does not require the expectation of a particular substantive outcome must be fulfilled. And I've heard this happening at the RTB, where sometimes the arbitrator, and I've only heard it happen rarely, I don't know if any of you have experienced this, but I have heard from clients that during the hearing, the arbitrator sort of suggested or stated how they were going to decide. Again, it's rare, but I've heard it enough to believe that some arbitrators are probably telling parties what they're going to decide before the written decision is actually issued. Now, this, unfortunately, I don't think would attract procedural fairness under the legitimate expectation doctrine, because, again, our decision makers are allowed to change their minds, and so this is not a situation that I think you could argue legitimate expectation. But I did want to highlight that just in case any of you have encountered that yourselves and wondered, well, what does this mean now? They told us at the hearing that they were going to cancel the notice to end, but then we got this decision saying that they weren't going to grant the tenant's application and they were going to issue an OP to the landlord. So I unfortunately, I don't think that would attract procedural fairness as a legitimate under the legitimate expectation doctrine. But another example, before a legitimate expectation can be totally dashed, the person giving the undertaking or the decision maker leading a person to believe they're going to be given some sort of outcome, they have to enhance their procedural protection. So, for example, if a person was granting a license, if they provided a notice or suggested an intention to not grant the license, despite suggesting that they should give that person an opportunity to make submissions before deciding that the decision to deny the license is made. So there might be an extra enhanced level of procedural fairness if that legitimate expectation might foreclose a certain possibility that the party should have an opportunity to speak to. Okay, so the choices of procedure made by the agency itself. The fifth bigger factor, this one is problematic. So the content of the duty of fairness does not just affect the person whose rights and privileges or interests are at stake. It also affects the decision maker, who might be required to have hundreds of hearings and decisions, and they might be overworked and overloaded. So if the court is to establish a workable standard, the procedural choices made by the decision maker must be taken into account in determining the requirements of the duty of fairness. The decision maker has superior knowledge, not only of its needs, but also the needs of the community it serves. So again, a court may be deferential to a decision, to a particular tribunal, because the court is not the expert in in that community that tribunal serves, or an expert in the legislation. So this might be a situation where they're very deferential to the tribunal itself. An important task of tribunals in responding to applications for judicial review is also to educate the court on the processes, because again, oftentimes when you are bringing a tribunal decision to the attention of the court on judicial review, courts have zero clue about that particular area of law. And the RTB actually has to give the court some education and explain to them. And oftentimes that's what they do is, they'll talk about limited resources and whatnot. So that's pretty common for the tribunal if they do show up, or at least to provide a submission explaining limited resources and why the decision maker chose to perhaps deny procedural fairness in a particular way. In Baker, Leroux-Dubé stated that important weight must be given to the decision maker's choice of procedure, but this provides little meaningful guidance, especially if the other factors support claims to greater procedural protection. So what does it mean if we weigh all the other Baker factors, and all of those Baker factors weigh in favor of providing a high level of procedural fairness in a particular context, but then when we get to this fifth Baker factor, can it completely overrule all of that because the tribunal says, well, we have to do it this way. There's no other way for us to do it. We can't be efficient. We can't keep up with our workload unless we do this particular thing, or unless we, and that particular thing might amount to a breach of procedural fairness. And so it does cause, this fifth Baker factor does cause concern with respect to maintaining the integrity of procedural fairness. It may limit the procedural protection required to be afforded by administrative tribunals, tempering judicial review of agency processes, which may be deficient or actually compromise fairness. There are no limits to the justification an administrative body may offer when compromising procedural protection in the name of their choice of procedures. And it can create a sort of backdoor importing deference to institutional choices of procedures into the test for procedural fairness. So again, this kind of, this factor could foreclose upon all other factors that would point to high degree of procedural fairness. So for example, the allocation of resources may be used to justify the failure to provide procedural protections, all in accordance with the procedural fairness. Another good example is there's some empirical work conducted by Professor Lauren Sawson into whether or not interviews are provided to those claiming immigration status on humanitarian and compassionate grounds. And so the failure to provide such an interview or an oral hearing was one of the grounds on which Ms. Baker unsuccessfully asserted a failure of procedural fairness in the Baker case. And Professor Sawson's research suggests that interviews are afforded in smaller regional offices, but not in the busy urban offices. And so that's seen as being okay. The fact that if you live in one community, you're going to get that interview, but if you live in another community, you're not going to be granted that interview because of, sorry, is everything still good? I just got a message from Zoom saying I was signed out, but I see everything still.
I think you're fine, Danielle.
Okay.
We see you and hear you.
Okay. Thank you. I was worried that maybe my screen, I don't know, froze or something, but good to know. Right. So, it would be unfair to think that someone who's located in a certain area isn't going to get that in-person interview, but someone located in another area will, all for reasons like resource allocation. But those are the kinds of factors the court will actually consider when determining whether or not someone is entitled to procedural fairness. And the court may very well say it's okay that certain people do not get those in-person interviews given the nature of that office and their inability to actually have these in-person interviews. So the fifth Baker factor can be problematic. Okay, so now we're going to start to go into some of the specific components of procedural fairness. And so once a court determines the general level of procedural fairness, they're then going to decide from a range of possibilities what specific procedures are required. And there are many possibilities. This list is definitely not exhaustive, but these are the more the kinds of procedural fairness issues that are most popular and come up most often. It's important to know these because, as an advocate appearing before an administrative tribunal, when you feel like you're being denied procedural fairness, it's important to raise that concern in the hearing itself. Oftentimes, if a decision moves on to judicial review, if certain things aren't raised at the tribunal level, the judge isn't going to look at them anyways. So it's very important to always, when you feel like you're in a situation where you might be denied procedural fairness, it's always good to assert with the tribunal member, procedural fairness requires me to, cross-examine a witness or and then, you sort of force the tribunal member to articulate why they might be denying you that pretty common aspect of procedural fairness. So it's really good to know what types of procedural fairness you are entitled to. And I have produced some cases, again, in the residential tenancy branch context that do stand for certain propositions in terms of the level of procedural fairness with respect to these specific components that are required at the tribunal level. So always good to keep them in your back pocket. And once you sort of are in a situation where you're appearing at a tribunal and you start to feel that, something doesn't seem right, it seems like there's been a breach of you and your client's procedural fairness, then always good to raise it at that point. So the specific components that we're going to talk about today are notice that the decision is going to be made, disclosure of the information on which the tribunal will base its decision, some opportunity to participate or make views known, a full hearing, an opportunity to give evidence and cross-examine, a right to counsel, and oral or written reasons for the decision. And so these considerations are really a way of asking, to what extent must the administrative decision maker act like a court? We also need to think about who is better situated to determine what the various procedures the tribunal should follow. Is it the tribunal or is it the court? And again, this is that tension that's really tricky and really difficult because, again, courts are not involved in the day-to-day operations. They don't have that expertise that the tribunal has. So oftentimes the court can defer and will defer to the tribunal's reasons for denying procedural fairness to a party. Can courts really understand the day-to-day reality, costs, and impact of requiring different procedures from those that a tribunal would select itself? Do individuals have a right to be represented in a particular tribunal? So all of these questions kind of underpin procedural fairness at its base level. Okay, so we'll talk about notice. Notice is sort of the most basic aspect of the duty of procedural fairness. It's the starting point for participation to any decision-making process and involves consideration of the following: who is proposing to make a decision? What is the nature of the decision being made? When will the decision be made? Where will the decision be made? Why is the decision being made? And how is the decision being made? So the requirement of notice are often prescribed in the tribunal's rules of procedure or in legislation. And where they are not, litigation may arise over questions concerning timeliness and sufficiency of notice. The court will certainly ask questions like, was it timely in the sense that it provided adequate time to allow a recipient to respond? Did it provide sufficient information to allow the recipient to respond? Did it provide sufficient information to allow the recipient to make an informed response? So this goes to questions about, too, what does the party know the case? Do the parties know what's being argued? Do the parties know the cases against them? How much notice are they given to prepare for that? Again, in the RTB context, there are timelines around when everything can be submitted to the other side, timelines regarding notice. And then, of course, arbitrators have the discretion to extend those timelines. But the general rule has been stated as follows: notice must be adequate in all circumstances in order to afford those concerned a reasonable opportunity to present proof and arguments and to respond to those presented in opposition. So the requirement to provide notice should be understood as an ongoing duty. It doesn't just start and stop at a particular moment. It arises prior to making the decision, and it continues throughout the course of the decision-making process. A party whose rights, privileges, or interests are at stake is entitled to participate meaningfully in the decision-making process. And in order to do so, they have to be kept apprised of relevant issues that arise during the course of the hearing. Okay, now we're going to talk about disclosure. So the concept of disclosure is more of an issue in the criminal context. There's a case called the Crown and Stinthcombe. It's a Supreme Court of Canada case, and it held that the Crown must disclose all relevant material to the defense in a criminal proceeding. Proponents of administrative justice argued, though, that the Stinthcombe disclosure principle ought to apply in the administrative context. But this, unfortunately, was rejected in a case called May and Ferndale Institution. It's a Supreme Court of Canada case. In this case, the court stated that it's important to bear in mind that the Stinthcombe principles were enunciated in the particular context of criminal proceedings where the innocence of the accused was at stake. Given the severity of the potential consequences, the appropriate level of disclosure was quite high. In these cases, the impugned decisions are purely administrative. These cases do not involve a criminal trial, and innocence is not at stake. The Stinthcombe principle does not apply in the administrative context. And so, although this case appears to completely reject the idea that the Stinthcombe principles apply in administrative law, the court did make clear that the duty of procedural fairness generally requires that the decision maker disclose the information they relied upon. Now, the question is not whether disclosure is required in administrative proceedings, but how much disclosure is required in a particular proceeding. And I think this certainly comes up in RTB settings. Sometimes an arbitrator will come back and reference a piece of evidence that was not discussed during the hearing. I'm dealing with this right now, where an arbitrator said a particular piece of evidence wasn't relevant, and it was a piece of evidence that was missing. And then when the parties mentioned that piece of evidence was missing, the arbitrator said, "Oh, it's not relevant." But then later, the decision comes out, and sure enough, that piece of evidence is cited and makes up part of the decision. So that's an example of this. This is an example of where the disclosure principle could apply. I mean, the arbitrator can't rely on a piece of evidence that wasn't properly dealt with by the parties or in the tribunal. And I think some of you may have encountered this yourselves as well, where there's a particular piece of evidence that isn't discussed at all, and then you get the decision, and boom, there's this evidence that was relied upon by the decision maker that no one mentioned. And a lot of these RTB decisions have, these pro forma paragraphs in the beginning that will say something like, "Oh, I'm not going to look at any other evidence other than the evidence that the parties pointed me to," which to me would create a legitimate expectation that the arbitrator is only going to look at the very specific pieces of evidence that were raised in the hearing. So when you get a decision that references a piece of evidence that wasn't raised despite that paragraph, that could be an issue of procedural fairness in regards to the disclosure requirements. So tribunals required to conduct oral hearings are likely to also have disclosure obligations spelled out in the rules of procedure. And as I mentioned, the residential tenancy branch does. And the courts have held that in some circumstances, such as the possibility of the loss of livelihood again, that requires a high level of disclosure protection. And ultimately, the duty of fairness is satisfied if a party has sufficient information to make informed submissions in regards to a particular matter. Now, there was a case, BC Supreme Court case called Suri and Vara. And in this case, the court confirmed that the landlord's decision not to disclose to the petitioner a key piece of evidence, which the respondent relied on at the hearing, resulted in a denial of procedural fairness. So similar to the case I described earlier that I'm currently dealing with, this case, Suri and Vara, confirms that not disclosing a piece of evidence that the decision maker relied upon is a problem and would amount to a breach of procedural fairness. Okay, oral hearings. This is probably one of the more popular kinds of components of procedural fairness, especially with respect to the residential tenancy branch. There's certainly no shortage of decisions where parties have had trouble connecting to the hearing for whatever reason, and the court has adjudicated those decisions. And I am going to talk about them in just a moment. But first, what I'll say about oral hearings is that they might sometimes be required by the duty of fairness, but they are not the norm. You don't have a procedural right to an oral hearing. And the reason for that is that the state could not function if an oral hearing were required every time an administrative decision is made. In practice, the contents of the duty is informed, again, by the context in which a particular decision is made and varies in accordance with a number of factors. A lot of tribunals rely on written submissions. I think the Workers' Compensation Appeal Tribunal, even though you're often dealing with credibility of the worker in that situation, they often choose to have written submissions, and I think that's increasing more and more. Yeah, so everything really depends on what the duty is understood as requiring in the circumstances. And so fairness requires the procedural protection the courts think ought to be required before a decision is made in a particular circumstance. And again, the right to a hearing does not mean a formal oral hearing is required. An oral hearing might be required in some cases, again, involving cases that are very similar to judicial types of proceedings. Those will be more likely to require oral hearings. In other contexts, the requirement may be satisfied by, again, written submissions. And whether an oral hearing is required depends on the relevant circumstances. However, some of the circumstances that require an oral hearing are well settled. So when a decision depends on findings of witness credibility. And there's a case called Singh and Minister of Employment and Immigration. It's a case from 1985, but in this case, the court held that a person claiming convention refugee status was entitled to an oral hearing. That was because refugee status depends on whether a claimant had a well-founded fear of persecution in their homeland. And this was not something that could be sorted out through a paper hearing. It certainly makes you think about Baker, because in this case, the court rightfully acknowledged that an oral hearing was required in a situation where the test requires a well-founded fear of persecution. And in Baker, Ms. Baker wasn't entitled to an oral hearing, even though one could say that that probably dealt with issues of credibility as well. But nonetheless, whenever the matter deals with issues of witness credibility, an oral hearing is required. Not so much an issue at the residential tenancy branch. Most of the hearings are all oral. I don't think I've ever heard of a hearing proceeding at the RTB by way of written submissions. But other tribunals certainly do rely on written submissions as opposed to oral hearings. But certainly you can object to that and claim procedural fairness requires that you have an oral hearing in a certain matter. We also have a case, I mentioned the case Kekals, and again, the citation for that is 2009 BCSC 1642. And in this case, the court set aside both an initial decision and the refusal to reconsider that decision where the dispute resolution officer did not hear from one of the parties, just didn't hear from them at all. So we know that will amount to a breach of procedural fairness when a party is not given the opportunity to be heard. Several other cases in regards to oral hearings and the RTB context in Ganetano and Metro Vancouver Housing Corporation, the court said that this was also a decision that was tainted by an unfair process. The petitioner had encountered problems connecting to a telephone hearing as a result of a mix-up. And I think this is pretty common. I've certainly seen many tenants who've come to us who have received a negative decision because of their inability to connect to the call, whether it was technical difficulties, whether they misunderstood the notice. I've certainly heard of a lot of people thinking that they were expecting the call. They thought the tribunal would call them instead of calling into the hearing. I think that happens commonly, but nonetheless, there are a whole host of reasons why someone might not be able to connect to the hearing despite their willingness to do so. And despite the fact that they've sent in submissions, they've sent in evidence, and everything would suggest that they plan to proceed with the hearing, you still have these bad decisions by the residential tenancy branch that often will deny a tenant's application because they waited on the line for 10 minutes and the party didn't appear, so they hung up. Another case, Johnson and Patry, the also RTB dispute resolution officer had abruptly terminated a phone hearing without allowing any further evidence or submissions and rendered a decision 4 days later. The petitioner had not been given the opportunity to call several witnesses. Their advocate was not permitted to make submissions on whether the existence of a tenancy agreement had been established. So again, no shortage of cases in the residential tenancy branch context that deal with the denial of a person being denied the opportunity to actually state their case and participate in an oral hearing. And then there's also a case called Poteco, my apologies if I mispronounced that, and Red Door Housing Society. And in this case, although the arbitrator may have been entitled to the rule that they would not admit the evidence contained in the evidence package, the court determined that the arbitrator was not entitled to do so without first giving the parties an opportunity to be heard and to make whatever arguments were available to them as contemplated by Rule 11.5. This is an older case. The rule numbers have since changed. I believe that is now Rule 3.7. And Rule 3.7 says that the arbitrator has the discretion to determine whether to accept documentary or digital evidence that does not meet the criteria established above, provided that the acceptance of late evidence does not unreasonably prejudice one party or result in a breach of the principles of natural justice. Both parties must have the opportunity to be heard on this question of accepting late evidence. And again, this is a good reason to always review the rules of procedure, because when you read this, we know that, well, an arbitrator can't just decide that they're not going to accept evidence without listening to the parties and without actually making a determination of whether or not the late evidence is going to unreasonably prejudice one party or result in a breach of natural justice. And, definitely have seen a lot of decisions where the arbitrator will just refuse to accept evidence because it was submitted late without actually applying this rule and going through that test, without giving parties the opportunity to speak to the matter and without making any findings on whether or not that delay would actually prejudice any of the parties or whether it would breach natural justice. So, again, very important to read the rules closely and just know them really well, because I don't think arbitrators know them that well oftentimes, and they won't apply their own rules of procedures. And this is the kind of rule that would kind of entrench ideas of procedural fairness in their process. So, and we have this case that says a failure to go through that test will amount to procedural fairness. So good thing to keep in mind. So unfortunately, there is no right to counsel in the context of an administrative proceeding, although the right to counsel is constitutionally protected by Section 10B of the Charter. The protection of that right is limited to circumstances of arrest and detention. And in a case called British Columbia and Christie, the Supreme Court noted that the right to counsel was understood historically as relevant only in the context of criminal law, and there was no general constitutional right to counsel. The court has held that where there is a deprivation of life, liberty, and security of the person, the principles of fundamental justice may in some cases require the provision of counsel in administrative processes. And that was a case where an applicant was at risk of losing custody of children in a proceeding brought by the state. In a case called Whaleby and Lafleur, It's a 2006 case. I have it reproduced for you there. This was a case involving an arbitrator's refusal to grant an adjournment to a person to obtain legal counsel. So although there isn't this right to counsel, there are situations where parties might have the opportunity to, let's say, adjourn a hearing so that they can secure counsel. And so in this case is one of those examples. So the arbitrator refused to grant an adjournment to Miss Welby to obtain legal counsel. And so Miss Welby had arranged for an advocate during her first hearing, but the advocate didn't show up, and she didn't know that was going to happen. So she couldn't prepare. The advocate just didn't show up. And so she was granted an adjournment. At the next hearing, the hearing that was adjourned, she explained to the arbitrator that she still didn't have the opportunity to secure a representative and requested another adjournment. Her request for an adjournment was not granted. So she appealed, or she applied for judicial review, and the court found that Ms. Welby had significant disabilities that made it difficult for her to present her case, and she had consistently maintained that she needed assistance in effectively presenting her position because of her disabilities. The arbitrator was aware of this. She had explained this to the arbitrator on more than one occasion. The arbitrator also considered that Ms. Welby had legal training in declining the adjournment when her medical condition was the reason she wasn't able to practice law. So the arbitrator in this case said, well, I'm not going to grant you the adjournment so that you can find someone to represent you because you have legal training, so you should be able to represent yourself, even though Ms. Welby, as a result of her disability, wasn't actually able to practice law. And so the court went on to say that the court went on to say that Ms. Welby was aware of legal support in her community, and she knew that she needed more time to obtain it. And because she had significant disabilities that were exacerbated by the stress of potentially losing her home, she required more time that would ordinarily have been the case. The court found that there is no record to assess whether or not Ms. Welby was able to present her case without assistance, but her written submissions, there was a cross-examination that happened that there were some issues with, and a failure to call witness indicate that she was unable to do so. So given all the circumstances, the court set the decision aside because Ms. Welby was not provided with procedural fairness in requesting an adjournment. So in cases where, I don't think it's going to be every case where a party argues that they need an adjournment in order to speak to an advocate or to obtain representation. I don't know that in all cases that's going to amount to procedural fairness if that request for an adjournment isn't granted. But certainly this case suggests that there are situations where procedural fairness requires the granting of an adjournment for a party to obtain counsel, especially where a party has demonstrated maybe some difficulties with being able to represent themselves and an effort towards obtaining counsel or an advocate and not being able to do so. So again, there's no bare right to counsel, but certainly there are situations where a party can request an adjournment where fairness would require that be granted. Now, this case can be contrasted with the PHS Community Services Society and SWAIT case. I don't have that in the slide, but this the citation is 2018 BCSC 824. I think some of you are probably familiar with this case. In this case, PHS was actually the petitioner, and they actually argued that they were denied procedural fairness because they weren't granted an adjournment to seek counsel. And the court said that, stated that as to whether the failure to grant a full adjournment was in all circumstances fair, court was satisfied that it was, that the fact that the arbitrator did not grant an adjournment was not procedurally unfair. The court said that the stated prejudice to PHS was a lack of time to consult counsel and prepare material, but the court found that that PHS was actually given an additional time to submit evidence and to make submissions in writing after the hearing. So the arbitrator directly addressed the alleged defect in fairness and provided the petitioner with the remedy by giving them another opportunity to provide submissions. So even in a professional, and then the court goes on to say that even in professional disciplinary matters, fairness does not create an unassailable right to counsel that will always require an adjournment. So those cases are contrasted. In the PHS case, PHS was asking for more time to hire a lawyer, and they were actually granted this additional time to provide submissions. So the procedural fairness issue was corrected by the arbitrator. But in this case, the court does confirm that there isn't an unassailable right to counsel that will always require an adjournment. So again, very context specifics, depends on the facts of the situation. And the more difficulties or challenges a party may have in being able to represent themselves, I think the more likely it is that procedural fairness will require the opportunity to adjourn in order to obtain counsel. Okay, next component is the right to call evidence and cross-examine a witness. And again, in the RTB context, I have heard many instances where arbitrators did not allow parties to call evidence or to cross-examine a witness. Some arbitrators take a lot of control over the hearing and really just want, the parties to I don't know what they expect the parties to do. They really just take control, and they don't want the parties or give the parties the opportunity to ask questions of the other side or to allow for certain evidence to come in. They want to sort of guide their own hearings. So I think some of them more than others, and I'm sure we all know which arbitrators those are, will just, again, take that control, oftentimes not allowing parties to actually speak or give evidence. And I've heard of situations where arbitrators will ask the advocate to speak on behalf of the client or the advocate to give evidence instead of the actual client. And all of those things are obviously problematic. Now, the right to call and cross-examine witnesses is, again, normally part of the right to an oral hearing, but the right is not absolute, just like all of these components of procedural fairness. None of these rights are absolute. And because administrative actors control their own procedures and because of that, they can limit the exercise of that right if they have a reason for doing so. Now, the guiding principle here is that parties must be afforded a reasonable opportunity to present their case. And this comes from a case called Innisfil and Vespra. And in Innisfil case, the court emphasized the right of cross-examination is not withheld on the basis of a judgment by the tribunal, that it is of limited utility. So it will be a breach of procedural fairness if the tribunal does not allow a party to cross-examine a witness. And the reasons for doing so would be that the tribunal member or the decision maker feels that cross-examination would be of limited utility. That's not acceptable, and that is likely to result in a breach of procedural fairness. Again, because most of the tribunals you all deal with are quasi-judicial, they are very closely resembling courts. I think that the inability to cross-examine or directly examine your client is going to be afforded a high degree of procedural fairness. I didn't do a super thorough, in-depth review on that in terms of the case law, but nothing really strong. There weren't any strong cases, but I think, the ability to cross-examine and direct examine are pretty fundamental tenets of procedural fairness. So I think if you're in a situation where an arbitrator is not allowing you to do that, then you can most certainly cite procedural fairness would require that they give you the opportunity to cross-examine a witness or examine your own client, because otherwise, how else is evidence going to actually come out if that's not happening? Okay, timelines and delay. So not all administrative decision makers are under a statutory timeline for holding hearings or making decisions. However, the RTB does have a statutory timeline. Section 77 subsection 2, I believe it is, 77 subsection 1D says that a decision has to be given promptly and in any event within 30 days after the proceedings conclude. We all know that usually arbitrators are issuing decisions the same day or the next day, which is an issue and a cause of concern in and of itself. However, I have also heard of situations where the 30 days have passed and there's still no decision. And so it was inevitable that the question of delay would arise in the context of administrative proceedings, despite the relative advantage administrative tribunals are presumed to enjoy over the courts. There is a pretty important case on this issue of timelines is a case called Blenko. Yes, I have it there for you. The Blenko case. And in this case, it involved a former minister in BC who sought a stay of a human rights proceedings in complaints against him. And I think several of his co-workers had complained that he had sexually harassed them at work. And over 30 months after the date of the complaint were filed, his career came to an end and he was dismissed from cabinet and expelled from caucus. And so what he tried to do is 30 months after, he wanted to stay the human rights proceeding, to put it on pause, essentially. And inevitably, that would deny these women their right to have their complaint heard by the tribunal. And so the court concluded that the stay of proceeding would constitute an abusive process and that the minority of the court considered a stay of proceeding was inappropriate and would have made an order to expedite the process instead. So in that case, Blenko, the respondent, tried to delay the process by trying to stay the proceedings 30 months after the complaint was filed. And so the majority of the Supreme Court concluded that undue delay in an administrative proceeding might impair the fairness of a hearing and could result in the abuse of process, even if the fairness of a hearing were not compromised. However, the majority of the court concluded that the delay did not infringe Section 7 of the Charter or the duty of fairness. And the minority of the court set out a three-part test that has to be balanced in considering complaints of administrative delay. So one is the time taken compared to the inherent time requirement of the matter, which would encompass legal complexities and factual complexities. Two, the cause of the delay beyond the inherent time requirements of the matter, which includes considerations of such elements as whether the affected individual contributed to or waived parts of that delay, and whether the tribunal used as efficiently as possible the resources it had available to them. And third, the impact of the delay, considered as encompassing both prejudice in an evidentiary sense and other harms to the lives of the people impacted by that delay. And this may also include a consideration of the efforts by various parties to minimize negative impacts by providing information or interim solutions. So other jurisdictions have applied the Blenko test. I didn't see the test applied to any cases in BC. However, that doesn't mean they can't be used. Still can be raised. And although in rendering a decision may breach the duty of fairness, the normal remedy for delay is likely to be an order requiring the tribunal exercise the duty expeditiously. So in some contexts, it might not really be valuable or useful. If 30 days have gone and a person didn't receive a decision related to an eviction notice, that might not impact the party because that gives them sort of more time to maybe think about what they want to do, or they're not in a situation where they're having to scramble. Likely they eventually will, because the landlord's still probably going to be granted a 2-day OP, but it may not be the kind of situation where you want to go to the court and try to get an order for the decision to be expedited. Other situations like outstanding repair orders and monetary orders might be more suitable. But again, you might run to the court, file for judicial review, and then have the decision issued during the course of that time. So the utility of this may not be so useful in the types of work most of us are doing, but it is important to know that is something that is considered part of procedural fairness. Okay, and the last sort of component of procedural fairness is the duty to give reasons. So this is what we at class deal with most often. And for those of you who may not know, at class we assist parties with judicial review. We do focus on eviction matters. So we're seeing a lot of these decisions being issued. And I feel like most of the judicial reviews that we take on have a component of inadequacy of reasons involved. Historically, there's actually no duty on administrative decision makers to give reasons. That changed because of Baker, and that changed because of several subsequent decisions after Baker, including a BC Supreme Court decision called Lavender and First United Church Social Housing Society. I don't know if Amber Prince is on here, but that was a case that Amber Prince was involved with. So way to go, Amber. That case really helped to swing the pendulum back to being able to argue that the reasons of a tribunal decision were inadequate. And so in Lavender, the court says that when there is a statutory requirement to give reasons, and in the residential tenancy context, the RTB does have to give reasons. They are statutorily required to give reasons. The standard of pain and unreasonableness applies to the consideration of adequacy of reasons with a focus on an assessment of the justification, transparency, and intelligibility in the decision-making process. So although the duty to give reasons is a component of procedural fairness, because that duty of procedural fairness to provide reasons was actually now entrenched in legislation, we don't attack it from the procedural fairness perspective anymore. What we do is we attack it from the sort of patent and unreasonable standard and saying that inadequacy of reasons lead to a decision that's not justifiable, that's not transparent, or not intelligible. And again, I can say in terms of the residential housing context, oftentimes reasons are not adequate at all. Reasons are supposed to allow parties to know why a decision was made the way it was, what evidence was relied upon. If certain evidence wasn't relied upon, then why wasn't it relied upon? Arbitrators are supposed to expand on that in their reasons. If an arbitrator chooses to believe one party over the other, we need to know why. We need to know why the arbitrator found one party credible and not the other party. So again, those of you who work in the residential tenancy branch and have experience with the tribunal will probably know this all too well, where you get the decision back and you really don't know. There's not much there. So as I mentioned, we usually are often judicially reviewing decisions because of the inadequacy of reasons. And so this principle of justification and transparency, again, require the decision maker, they're supposed to also meaningfully account for all of the central issues and concerns raised by the party. Arbitrators have to also analyze and grapple with the full test that's provided for in the statute. And one example of that is some of you may be familiar with the case MBB and Affordable Housing Society. And that case basically stands for the proposition that an arbitrator, just because we know they do this often, if a party doesn't attend the hearing, they wait on the line for 10 minutes and then they dismiss the application. And so the MBB case was a case where MBB was given an eviction notice. There was a misunderstanding about the call-in details due to a language barrier. So MBB didn't call into the hearing. As a result, the arbitrator just dismissed MBB's application to cancel the hearing without going through the test as to whether or not the landlord met the burden to end the tenancy. And so on judicial review, the court said, tribunal, you can't do this. You can't just dismiss MBB's application to cancel an eviction notice because they didn't show up to the hearing. You still actually need to go through the legal test. You still need to determine whether or not the landlord has established that they had the grounds to end the tenancy. You can do that in the absence of the party, but you still need to undertake that analysis. You cannot just dismiss on the basis that someone didn't show up to a hearing. Even though the MBB case exists, arbitrators continue to do this. So I'll take this moment to plug class, and if you're getting these decisions, to certainly send them our way, because since MBB, I've seen numerous cases where arbitrators continue to just dismiss on the basis that the party didn't apply without actually going through an analysis of whether or not the landlord met their burden in these cases involving notices to end. So yeah, apparently the RTB doesn't always follow binding case law. So just getting back to this, so where the duty of procedural fairness or the legislative scheme mandates that reasons will be given to the affected party and then have been given, this failure will generally require the decision to be set aside. So again, in the RTB context, they are required to provide reasons, and we can certainly attack those decisions when the reasons are not adequate and they're not intelligible. We really do not know what the arbitrator meant or how they decided or how they reasoned. So now we're going to talk about bias, independence, and institutional decision-making. Not going to get too much into it. I'm mindful of the time. I think we have about half an hour. But we are going to, I think it's important. I think this comes up often. And again, in the RTB context, I think there are a lot of concerns about the RTB's function as a tribunal, and certainly heard numerous instances of parties feeling like there was bias involved in the decision-making process by the RTB. So we'll start with independence. If a decision maker acts in a biased manner, favoring one party over the other, what do we do then? What do we mean by bias? Do we mean we have to have actual evidence that the decision maker already made up their mind or that they've been bribed in a particular way? Or is it enough that, given all the circumstances, there's just an appearance of bias? And we're going to get into bias a bit more. Independence, impartiality, and bias all kind of center on the notion of fairness in the administrative decision-making process. And so a key characteristic of a fair proceeding before an administrative body is that the decision maker and the decision-making process aren't supposed to grant undue preferential treatment or be driven by preconceived notions. This is not only vital to the litigants involved, but it's also vital to the public's confidence in the administration of justice. And the more people are involved in these processes and start to feel like these kinds of biases are inherent in the process and inherent to certain individual decision makers, they're going to slowly begin to distrust that system. And I think we see a lot of that, again, with respect to the residential tenancy branch. I think a lot of people who've had to appear before the tribunal have lost confidence that justice is being done because of the appearance of bias or for whatever reason. Now, if bias is the evil we are trying to avoid, impartiality is the ideal state of a decision maker, and impartiality refers to a decision maker who's able to make judgments with an open mind and without having their mind already being made up before they actually listen to the parties. Independence is the means to achieve impartiality. So, for example, by ensuring that an administrative tribunal is not too dependent on government for the necessities of its day-to-day function. Tribunal independence raises several questions. To what extent should tribunals be independent of the branches of government that have created them? How can tribunals best fulfill the function for which it has been created while maintaining an appropriate distance from government, litigants, and other stakeholders? So most tribunals do have a link with the executive branch of government through a minister and are generally required to have some contact with the minister, as we know. 3 objective structural conditions have been identified as necessary to guarantee decision-making independence. One is security of tenure. So the type of interference targeted here is the ability of government to remove a decision maker for such things as rendering decisions that do not meet government's approval. 2, financial security. aims to satisfy two goals. First, guarantee that pay will not be altered for arbitrary reasons, such as discontent with the decision, and that the amount promised will be sufficient to keep them from seeking alternative means of supplementing their incomes. And three, administrative or institutional control. And that deals with the manner in which the affairs of the court are administered from budgetary allocations for equipment to the assignment, for everything from equipment to the assignment of cases. So these three conditions for decision-making independence apply to judicial decision-making. We're going to see how they apply to the administrative tribunal, but this is how we try to distance the courts from government. And so these three factors serve to reassure the public that the possibility of interference in judicial decision-making by the executive and legislative branch of government have been reduced, if not eliminated. So that's why judges get paid an incredible amount of money to be judges, because it's meant to reassure the public that there's not going to be any temptation to decide in any particular way, and to be free from bias. So over time, though, these three criteria guaranteeing independence of the judiciary have also served as the foundation from which courts have determined whether administrative tribunals are also sufficiently independent. But given the differences between courts and tribunals, we will see that it's hard to apply that context to tribunals. So the test for adequate tribunal independence is whether a reasonable, well-informed person having thought the matter through would conclude that an administrative decision maker is sufficiently free of factors that could interfere with the ability to make impartial judgments. So this is called the reasonable apprehension of bias test. It also applies to independence as well. And the methodological approach taken by the courts when the independence of an administrative tribunal is challenged consists of applying the guarantees of tribunal independence in a flexible way to account for the functions performed by the tribunal under scrutiny. So essentially, tribunals do not have the same guarantees of structural independence as the courts do. And there has been some considerable jurisprudence regarding the appointment of tribunal members. It seems like that was a very contested issue in the early 2000s. And some provinces have actual legislative enactments to ensure tribunal members do have fixed term appointments. And the Administrative Tribunals Act here in BC does state that a member of a tribunal does have a fixed term appointment. So we do have that legislated. I'm going to skip over some of this on these slides on independence. I don't think it comes up so often, just mindful of the time. I think it might be more applicable if we kind of go into reasonable apprehension of bias and finish off today's presentation with that. You'll notice the slides are very dense. And so that is done on purpose because I always imagine I'm going to run out of time. So I try to put as much information on the slide as possible because I know you'll eventually get that. So I'm going to skip over a lot of what I have, but I do want to bring your attention to, now I just have to see where this McKenzie case. Okay, there we are. So the previous slides, you will have seen that there's a case called Ocean Port Hotel in British Columbia, and that stands for the proposition that there's no freestanding constitutional guarantee of independence for administrative tribunals. court held that constitutional guarantees of independence serve primarily to protect the judiciary from interference by the executive. They cannot work to protect tribunals from the branch of government from which they themselves are a part. So despite the decision in Oceanport, advocates do maintain that this independence can be guaranteed by the unwritten constitutional principles that protect our courts of inherent jurisdiction. And thankfully, we actually have a case here in BC called McKenzie and Minister of Public Safety. And it's an interesting case because a bit of background on this case. So the Minister of Public Safety had actually rescinded without notice the appointment of a petitioner. And the petitioner was actually an arbitrator, a residential tenancy branch arbitrator. So her employment was rescinded without notice. And so this brought on a sudden and unexpected end to her career, which she had been in for 10 years prior. And so when Ms. McKenzie, the RTB arbitrator, was first appointed as an arbitrator, it was as a result of a merit-based competition. And at the time of her termination, Ms. McKenzie was in the midst of a 5-year term that had commenced on January 1st, 2004, and would have run until December 31st, 2008. So Ms. McKenzie argued that since several other courts seemingly on the outer edge of the judiciary have been deemed to attract unwritten constitutional guarantees of independence, so should RTB arbitrators. And so in McKenzie, court found the following, that judicial independence not only stemmed from specific provisions of the charter, but also derived from unwritten constitutional principles. There was a case called Alberta and L, and in that case, the Supreme Court of Canada determined that the unwritten constitutional principles serve to protect judicial independence of justices of the peace, which are a class of decision makers whom the issue of judicial independence has been debated apparently for some time. And judicial independence should apply to residential tenancy branch arbitrators. And so the success of the case, the McKenzie case, lay partly in the fact that the RTB arbitrators are similar to courts in most of the work that they do. And so I think this is a very important case, because it says it's a case that looked at the role of an RTB arbitrator and said that RTB arbitrators are similar to courts in most of the work that they do. So that can be cited for any procedural fairness issues when you want to argue that more procedural fairness, a higher degree of procedural fairness should be applied, given the work is closely resembling that of the court. And so this also kind of opens the door a bit for us to think about, actually understanding how the RTB functions a bit, and doesn't close the door on us being able to bring a case of independence, judicial independence with respect to the RTB. So thankfully we do have this case in BC that we can rely upon. I also want to note at this point that this is everything I'm talking about is basically common law that is rooted and grounded in Anglo-European notions of impartiality and independence, in which decisions are considered fair when they are made by those who are at a distance from other parties. But I do want to note that there are other conceptions of justice. And for example, some Indigenous communities consider decisions to be fair when rendered by non-strangers and by people who they know and they trust. So I just want to highlight that this is, of course, from a European Anglo-European perspective, and this is not the only way that the conception of procedural fairness and justice is conceived of. Okay, running out of time, but I think we should be able to get through reasonable apprehension of bias. So allegations of reasonable apprehension of bias exist in two major forms. There's perception of individual bias, which is dealing with the impartiality of the decision maker, and perceptions of institutional bias, which deal with whether the reasonable perceptions of partiality regarding the decision-making body as a whole can be raised. We're just really going to look at perceptions of individual bias. And so an allegation of perceived bias must also be brought to the decision maker by the party alleging it on the first available occasion. So as soon as you discover it, you should bring it to the attention of the tribunal or the decision maker. If the claim is successful, the effects will be to quash any decision made and to have the proceeding reheard by a newly constituted decision maker or panel. So perceptions of individual bias are situations where the decision maker may reasonably be perceived to have a pecuniary or material interest in the matter. Most often this is, that a decision maker stands to receive some sort of monetary gain. And in some cases, pecuniary interests may be held not to give rise to a reasonable apprehension of bias if the decision maker's gains is no more than that of the average person in a widespread group of benefit recipients. A personal relationship with those involved in the dispute. So this also includes relationships a decision maker may have to witness and counsel. But the key factor is certainly the nature of the relationship, and also time. Has enough time gone by that this potential bias may no longer exist? Is the relationship not the same? So time is certainly a key factor, and also the nature of the relationship. Just because someone's cousins with the decision maker doesn't necessarily mean that that's going to amount to reasonable apprehension of bias. Other factors would include prior knowledge or information about the matter in dispute. In that situation, the focus is on the nature and extent of the previous involvement. Again, just because a decision maker may have already decided this decision or these sets of facts in the past doesn't necessarily mean that it's going to amount to a reasonable apprehension of bias. It really depends on the nature and the extent of that involvement. And any allegation of reasonable apprehension of bias, there really has to be evidence of it. It can't just be a feeling. It can't just be that you think because they've done things a certain way that's amounting to bias. You really need to have good evidence of the bias to raise reasonable apprehension of bias. And the final factor is a sort of attitudinal predisposition toward an outcome. And so this includes antagonisms towards litigants, ex parte communications not involving all parties in some sort of communication, irrelevant or vexatious comments, or taking an unauthorized role as an advocate, which again, I'm sure we all may have experienced situations where the decision maker maybe had done that, where it looked like they were maybe taking a side, or they made comments that were inflammatory or vexatious that just could lead you to conclude that there was a reasonable apprehension of bias there. To give you, though, a sense of when the court's going to find a reasonable apprehension of bias, and there aren't too many cases in the RTB context of reasonable apprehension of bias. Most of the petitions for judicial review for reasonable apprehension of bias were dismissed because the court would often say, this is a very high bar. You need to actually have real evidence. You have to have a real belief here. And so the bar is high. And so a lot of them were dismissed. There was one case, though, I want to bring your attention to. It's a case called Sainaret and Bakonyi Holdings. And the citation for that is 2018 BCSC 994. And in this case, the tenant argued that the arbitrator had a reasonable apprehension of bias. And the allegations of bias were found in the transcript of the hearing, which the judge accepted. I actually believe the tenant in this case recorded the hearing themselves, and the judge did accept it. Now, I know we're all, those of us who do RTB matters, we're all waiting anxiously for the RTB to actually start to record hearings. They said they would, and we are a year later from when they said they would, and still nothing. And in this case, the tenant, even though the rules prohibit recording of hearings, in this case, the tenant petitioner did actually record it, and it was accepted by the court. Now, whether or not it's always going to be a transcript that derives from a recording of an RTB hearing, whether or not it's always going to be accepted, that remains to be seen. I don't know if anyone was there to point to the judge that the rules actually prohibit it. But in this case, the judge actually did accept a transcript. And we actually can see how useful transcripts are in these situations because they relied on the transcript for their claim of reasonable apprehension of bias. So they referred to a few parts of the transcript. The court stated that it was clear that the arbitrator felt that there were two opportunities to settle the matter and it didn't get settled, and that the petitioner tenant wasn't really prepared to make a decision about terms of the settlement. So at some point, the arbitrator said, you could be out in 2 days, and I was really trying to help you twice now, noting that the landlord was prepared to give 6 months occupancy, so the tenant petitioner had the chance to stay and clean up. Another part of the transcript, the arbitrator says to the tenant petitioner, she was tired of him causing delay and that he continues to abuse the process, and she was not going to allow that to happen. Another point of the transcript, the arbitrator makes it clear to the landlord that their evidence has to finish promptly. And another part of the transcript, the arbitrator says to the tenant petitioner, after where the arbitrator, the landlord had spoken for about half an hour, and then the arbitrator turned to the tenant petitioner and said, I'll need you to wrap up your submission soon. So, that's, I think, probably pretty common experience for a lot of people. And for some people, I'm sure there have been worse things that arbitrators have said to parties. But, you read something like that and you can see why the tenant petitioner in this case, decided to bring a claim of reasonable apprehension of bias. But unfortunately, the court did not actually find bias in this case. The court said that, in my view, the arbitrator is simply trying to control the process before her, and given the apparent guideline of the 1 hour hearing. So there's an example of the court looking at the context of the RTB and finding that the arbitrator wasn't actually biased in this situation. In fact, they were just trying to control the hearing so that it would stay to the 1 hour time frame. So again, we can see the hurdles that one would have to overcome in order to be successful in bringing a reasonable apprehension of bias claim to the court. And with that, I'll leave it. I don't know if there are any questions. I note that there weren't any throughout the presentation, but we do still have a few minutes if folks want to ask any questions.
Yeah. Hi, Danielle. Yeah, looks like there are no questions. Thank you. Thank you so much for such a wonderful wealth of information. And thank you, everyone. Have a good evening. There will be a survey in Zoom. Please fill it out. Your feedback is very important for us. Thank you.
Thank you, everyone.